Good evening, everyone. I'm your host, Abdullah Al-Mamun. Today, we are going to give you some basic information, generic information on UK immigration rules. There are many questions can be asked, and so many people are concerned and aware of the recent changes, but still there are some questions that people wanted to know what's happening within the immigration currently. So before I ask some questions, I would like to welcome Mr. Zahid Chaudhary, solicitor, to our show. Welcome to ZMC.
Thank you, Abdullah. Thank you for having me here today for this program. Thank you.
Right, audience, the question will be thoroughly whole program about immigration, UK immigrations, and also there are some other issues, and I can ask some information that Mr. Zahid Chaudhary can share with us from his experience, because he has been practicing within the immigration in the UK for many years now. So I hope he can invite our audience and tell us about his experience as well through our program. Right. So audience, before asking question in relevant to the UK immigration rules and changes, I would like to say a few words about these. The intention of our program is to give you some basic information, generic information, and it's not in any form of legal advice. If you need any legal advice, or should you have any specific questions that require legal assistance, you are suggested to contact your solicitors or any legal expert who has the required knowledge to give you the guidance in respect of your query. So let's ask some questions today. I'll start with the recent and current hot topic, if I may say that skilled worker visa. Then I will go slowly to different areas within the immigration that I can ask. So if I can ask you the question about that skilled work, the people are coming on a skilled worker visa, and they come here. They have been sponsored by a company. Once they arrive in the United Kingdom, we get some query about that they are not getting job, or company not offering the job. So in your experience and in line with this immigration rules, what is the consequences, what can be happening, what are the options available to them?
Thank you, Abdullah. This is a very sort of you can say sad situation, unfortunate situation. The people are actually coming here to work. Obviously, as you are yourself a solicitor, you know that when an employer or company issue a COS, certificate of sponsorship, they say, okay, we are offering this job. They give you a title of your job description, and they say to this gentleman, and the job will start from that date and the end date will be that.
Yeah.
So this means you are giving Home Office impression that this company does have a job for this skilled worker. That's why Home Office actually assign you that COS. And now, obviously, if someone comes here on a skilled worker visa or on a care worker visa, normally they say, care home visa, these sort of things. So if they come here and the employer say, okay, look, yeah, you are here now in the UK, so but unfortunately we don't have a job for you. So what this mean, and what are the consequences that you ask in this question?
Right,
yeah. The moment when the employer says, look, we don't have a job for you, so this means that your employer and you are actually in a breach of immigration rule. Let's suppose if you have a skilled worker COS, you come in this country and your job start from 1st of February. What this mean? This mean by the end of the February, you must have the required wage into your bank account, and you should have a relevant pay slip, and employer must have paid tax and national insurance contribution real time. Nowadays it's a real time. Like,
so I've got a question, sorry to interrupt you.
Yeah.
Some people, they as you said, they rightly come here, they got the COS and they got the visa, they entered the UK. The moment they entered the UK, they say they don't have that working place or working hour. The company is not giving them the work. So and also some people, as you are probably aware, that they're coming for 2.5 years or 3 years or 5 years, under the impression that after 5 years they can apply for settlement. Yeah. So can they still apply for settlement, or what will be that?
That's the biggest consequence, yes, which I always say, because in my practice I'm receiving numerous calls regarding these issues now. So this means, if like your job according to your COS was starting from February 2024, and your employer saying, no, I don't have a work for you. So this means your wages will not go into bank account in February. Okay, your national insurance contribution and the taxes will not be deducted by the HMRC in a real time manner. So this means, if you will make an subsequent application for extension or settlement, you will not be able to meet the requirement for the settlement or for the extension. So this means this employer actually put this gentleman or this applicant and skilled worker into limbo. So this means they wasted all their money, all their money. So
and the time.
And the time.
Yeah.
And again, Abdullah, obviously we are actually educating people through these programs, and this is saying to people, look, you must be 200% sure that your employer will provide you the job as the company or employer promised in COS.
So if now we know that from the conversation we are getting the impression that some people out there without proper employment,
yeah,
but on the paper they got the employment. So do they have any other choice, or can they take any second job, or can they leave the company if the company does not provide the job? Can they take any legal actions or something like that?
Again, question is no, as I said, if there is no job available to them, they are in a breach.
Yeah.
Obviously, there are some technicalities, like obviously a COS, a skilled worker, that's actually give you this opportunity. Okay, you have to work for your employer specified in that COS, but in addition to that, you can work in your
20 hours
in the same category,
yeah,
the same industry. So just imagine this, you are not having a job in your
job you're supposed to have.
Yes, yeah, and you say, okay, yeah, technically it is, you are still entitled to take 20 hours in another place, but in the same industry. But the question is again now, so what you will do, because your employer, now we have many cases where they say, oh yeah, I came in on a care home visa,
yeah,
so for last 6, 7, 8 months, so I didn't work. So what about these 7, 8 months? So this means all these months now wasted.
So he basically, if can they get away with it? Like I'm more concerned about now the employer. They're recruiting people, but they are not actually giving the work or letting people contribute to the national insurance or taxation. It's like, as you said, it's just a waste of time.
Yeah, Abdullah, because when they issued the COS, obviously they undertake that we are going to provide this employment to this skilled worker. But if the employer is not providing that that job and that work, so employer is in a breach of his or her responsibilities.
I'm going to ask you some different questions.
Yes, sure.
We can talk on this like minute after minute, and but got some other issues as well.
Yes.
Can I just ask you for this ZMC network audience, they can like you can enlighten us on this, that asylum claim and the Rwanda policy.
Yes.
What is the current situation in this?
Rwanda is keep coming up into our discussions. Obviously, it's almost not over 3 years now. We are hearing about this Rwanda policy. So your viewers should know this one. Rwanda policy, we are actually using the German terminology. This means this one, Home Office is saying UK government is actually proposing the people who will enter the UK unlawfully or illegal entrant, Home Office will relocate them to Rwanda. Okay, it's African country, and their asylum claims will be processed in Rwanda. So that's their plan, and UK government has already spent millions and millions of pounds for this plan. But unfortunately, so far, as a lawyer, I personally think that it is not working and it will not work. Although now they use the word safety of Rwanda immigration and asylum bill. Okay.
So regardless, I think the UK government are trying to say that Rwanda is a safe country, even though it's not safe, but they trying to.
Yeah, they're trying to give that impression. Okay, look, and as I said, they put the name of the bill is safety of Rwanda asylum and immigration bill. So they're trying to give that impression, okay, Rwanda is a safe country. On other hand, if you will see that UK government has accepted many asylum claims from citizens of Rwanda. What this mean? So this mean UK government is actually accepting that Rwanda is not a safe country. So this mean they are contradicting. The update is this one, obviously, because in a House of Commons it is a game of numbers, and at the moment government is having a considerable numbers to get through this legislation. So House of Commons has passed this bill, and now obviously this bill is currently at the House of Lords. House of Lords has currently refused to back this bill, and what they are saying, they are saying, no, look, we will consider it at some later stage. So obviously my understanding is they will discuss in the House of Lords, and they will actually send this bill back to House of Commons with some amendment. So, okay, do this amendment, let's come to it. But the crunch question is, asylum, how many people actually come to the UK as an illegal immigrant?
Like you mean by boat? Or
by boat, by bus, or behind the lorry, and this. It's only, I think, is less than 1%. Okay, and let me say 1%. 1% people actually come in this country without any valid leave. So out of that 1%, obviously you cannot send everyone to Rwanda. Why? Because you may have children, you may have women, okay, and government policy also is suggesting this.
It's like you cannot make a blanket decision to send everyone to Rwanda, whoever comes.
Whoever comes after the March 2023, before the March 2023, okay, we will send this one. So it means you have to decide every single individual case.
So can we precisely say this in the manner that Rwanda is still long discussion?
It is indeed. Obviously, it is still a subject to the further legal battle again now. But again, as you are aware, this one we are having a general election this year in the UK. So I think we will hear the echo of this referendum during this election campaign and all these sort of things. So, but as I say, even Home Office has sent some letters to people saying this one. Okay, yes, we are sending you to Rwanda. But when Home Office was contacted, what is happening this one, then the Home Office admitted now these letters were sent in
an error.
So,
another question is like a legal system, how it works. When we got the decision from the highest authority, the Supreme Court,
yes.
And do you think is there any chance that it can contradict the a separation of power, judiciary and executive power, and the parliamentary?
If you will see this one, separation of power is actually icon of a British judicial system. Okay, where I as a lawyer will say this one, this bill is actually contradictory with that separation of powers. In the presence of this bill, let's suppose this one, this bill get consent from both House and become an act. But this act will not have an effect on the Supreme Court decision. Supreme Court decision is still there.
That's
so
right.
what you will do that? It means you are actually having some parallel powers, and you are ignoring the Supreme Court decision.
I will ask one more last question on this. I'm just I don't know if I'm stretching it.
No, it's okay.
One more question on this. Like, do you think that can attract the human rights under Human Rights Article and the Human Rights Act 1998?
Yes, yes. Obviously, that is actually contradictory to Human Rights Act. And obviously, if you will see this this bill, they are actually saying, okay, the international courts, EU courts, and our own tribunal, they will have no power to say that the Rwanda is a unsafe country.
Then there is there may be again a conflict of
conflict of separation of powers. Yeah. So that's why, as a lawyer, I'm of the view that there will be again legal battle, because obviously the Supreme Court, the Apex Court, has already said that Rwanda is not a safe country, and you remember that that was a unanimous decision of Supreme Court judges. Yes. So what you but obviously because of this I say, and I will again say this one for last after the resignation of this Boris Johnson. Now they are just saying this, oh yeah, there is only one issues in this country, and that is, okay, send these 1% people, less than 1% people to Rwanda. There are no other issues facing the general public.
I'll go with this immigration matter again. For the ZMC audience. Another area that perhaps so many people or from the audience, they are aware, this international students.
Yes.
They came to the UK, and some of them they claimed asylum, and before the change of roles, and saying that they need to complete their education to switch their visa category or go to skilled work. But before that, the student claimed or submitted their asylum. They didn't complete their education. Some of them, they tried to or they are trying to switch
to the skilled work,
or they're still thinking, and it's their question basically, whether they have a still chance to switch or do something under skilled work.
Yeah, my understanding on that, obviously, we have to see, let me see a student actually claim asylum when actually he was having a proper leave or valid student visa. So now if we will take the asylum away, so it means that the student will come back to the original position that he is having a student visa. And now my understanding is, because at this stage a student is not entitled for switching to the skilled worker visa, so in my understanding the student will not be able to actually switch to the skilled worker visa because he has not completed his degree. So my understanding is.
Thank you. Thank you for the clarification. And can we, if I can ask you about this another sensitive area, the spouse visa.
Yes.
And also, I will ask you the mixed question. Take your time and please answer these questions. Like from the 6th of February,
yes,
the IHS is going up, and also very soon that UK government already announced that they are going to increase the financial requirement, the threshold. So if you can just give us a basic idea, what are the changes?
Again, obviously, because there is a lot of echo for the last couple of months now, a lot of speculations and suggestions actually. Obviously, currently, yes, that is confirmed now, because that rules, immigration rules, they have been passed now, and it's a law now. The IHS fee, immigration health surcharges, will be increased from 6th of February. Obviously, it currently is £624 per year. Okay, but now they are, I think, doing this £1,035 per year. So this means a huge increase, about 66% into that. So obviously, if someone want to avoid this one and they do have some application to submit, then they can submit before 6th of February. Otherwise, obviously, after 6th of February, they have to pay the new IHS fee. Second question which you said, obviously for a spouse visa, currently the financial threshold is actually 18,600. Initially our new Home Secretary James cleverly says, okay, it's the same, that will be the same £38,700. That was just an announcement. But then they say, when obviously there were a lot of questioning and concerns showed, that she says, okay, now we may do this £29,000. But still, this is just a suggestion. At the moment, there is no law, because it's not so simple. Like for example, okay, if you are going to do £29,000, so whether you are also going to increase the threshold for the kids. At the moment, obviously, if you are bringing a one child, you have to pay £3,800, I think.
The first child.
First child. So this means there is no information.
I think what they're trying to say, that if someone earns 29,000, they don't have to show additional income for the children.
Yeah, if they're saying this one.
This is again another suggestion.
Yeah, this is again a suggestion. But obviously, if they say this one, but again, there is another. If you see this one, like we do have some qualified benefits.
Yeah.
Okay, so if you are having like a carer allowance, so then you don't need to meet the threshold of. So whether the qualifying benefit will remain same. If someone is actually in a receipt of a paper disability living allowance or this carer allowance, attendant allowance, such as, so that person will be exempt from meeting £29,000. So it still is not clear. So this means government has to do a lot if they want to increase. But obviously, If they will not do their calculation properly in accordance with the current living standard, employment rates and these sort of things, they will again face a legal battle.
Since we are discussing about the cost and increase and other issues, I have another question and a financial threshold. If somebody wants to sponsor their spouse from overseas, a non-British spouse, then and also that applicant does not have enough money to afford the application fee, can they still apply to come to the UK as a spouse?
Again, currently at this at this stage, the law say this one. Yes, if you do not meet the financial threshold, still under Appendix FM Journal, if there are some exceptional circumstances, then obviously you can make that application. Similarly, again in Appendix FM is saying this one, if you have a third party spouse or if you have a genuine job for the applicant, then obviously all these things will be considered for that. But again, that's why I'm saying this one, because it's not too easy to saying, okay, so you earn £29,000, that's it. So what else? Are you going to change all these things which I have just mentioned? If you are going to do this one, so there should be some blueprint in front of all the immigration lawyer and practitioners. So they should have something, because they're saying this one. Normally, Home Office change in April. I
have the question pretty much similar. Spouse has financial threshold, or spouse is exempted, meeting the requirements that certain type of benefits they are receiving. But I'm saying that what about the application fee itself? Applicant does not have the money to afford it. Can they apply for fee waiver or something?
Yes, currently this option is available. Obviously, if you are not having means to pay the Home Office, because it's very expensive application.
It is.
Spouse entry clearance is that. So if you do not have a means to pay for that, then obviously you can make an application for a fee waiver. But again, it will depend on, if you make an application for fee waiver and that application is granted, then whether they will put you on a 10-year route or they will keep you 5-year spousal visa. Because obviously one side you saying this one, okay, look, I don't have means, and other hand your spouse is saying this one, okay, I meet the financial threshold, and say, okay, if you meet the financial threshold, then pay the fee. So but this option is available, as you said. Yes, if you can make an application for anti-clearance spouse application fee waivers, you can, if you don't have this these funds to pay, then obviously you can make that application.
And to make this application, how can a person make prepare their good application?
That's again what they want to see. When we obviously there are many application attracts a fee waiver option. What they want to see this one, you do not have means to pay the fee and IHS payment altogether. Okay, there are few possibilities, like you are not working. You're not working. Other option is, yes, you are earning, your spouse is earning, but if you will pay the Home Office fee and IHS payment, then there is a risk of you becoming homeless or destitute and these sort of thing. And especially if you do have kids, then obviously there is a risk of their well-being. So what they want to see, yes, show us for that, obviously both, in that case, both applicant from overseas and the sponsor spouse here, they both have to provide their 6-month bank statement, including their credit card accounts and these sort of things. And obviously then we have to provide a chart of our income and expenditure. Okay, all income and all expenditures. So obviously then they will see this one, okay, how much is the income and how much are the expenditures. So if they say, okay, yes, they don't have enough money, so there are then two possibilities. If they entirely they don't have any money, then obviously Home Office will give them a full fee waiver. Okay, but if the Home Office, okay, they have a little money to pay, so Home Office has a power to grant you partial fee waiver. So they can say, okay, we don't want you to pay this much, we want you to pay this much. So these options are available. So you have to make a really good case to the Home Office caseworker, convincing them, look, you don't have money, but if you don't have a little money, if you will pay this one, you may become a destitute, your child will suffer, and these sort of things. If you will make that kind of a good application, yes, because obviously this is in the law.
Yep.
So yes, if you don't have the means, make a fee waiver application.
I think we are running out of our time, but before we go, I have got one more last question.
Yes.
On this show. I think we have tried to cover almost all important issues. One more last thing that I said about European citizens and their family members who are living in the UK, that recently so many of them, they received email about automatically transfer, but still they are not receiving automatic settled status.
Yes.
They are receiving 2 years further extension. If you can briefly explain this.
Because obviously, you know, last year Home Office actually made this announcement and saying, look, we will do the automatic extension of people who are actually on pre-settled status, and they were also saying this one, we will look into that if the people are entitled for a settled status. I mean, they have completed now 5 years on a pre-settled status, so then we will also grant them automatic settled status. But I think now Home Office has U-turned on that one, and now they're saying, okay, yes, if you are having a pre-settled status, we will give you a 2-year extension, so you will not be out of your leave. But they are advising people, if they are entitled for settled status, so they should actually make an application for settled status. So that's why I will suggest to the people who are watching us, who are listening us, if they are entitled for settled status, so they should make an application. Otherwise, what will happen? The Home Office will grant them a 2 years extension. So obviously this is another one. If you are entitled for, so make that application. It's a free application. You don't need to pay anything. So I think they should make
it's easy also. If you have a smartphone or Android, you can easily apply.
Yeah.
But yes, Home Office are encouraging the applicants to make an application to save their leave in the United Kingdom. And I guess we are finishing our show for tonight, and I would like to thank you and thank you again for watching and staying with us, ZMC Network, and we will come back again with another show for another UK immigration updates with our respected guest, Mr. Zahid Chaudhary, solicitor. Thank you again. Thank you for watching ZMC.